The reference is needed. Lord, I have already argued the difference.
Solicitor, now it can't be now after Dr. Singhvi is in a rejoinder.
No, allow me, 2 minutes.
Looked at the matter very differently. I mean, there was the issue of reference was never been argued. I mean, we are now, your argument, your side is convinced.
I understood. My lord said that you can always cover it in your arguments.
No, but it was not covered in the argument. That's the point.
All points are covered without using the word reference.
With great respect.
We may not be remembered in history for having handed over, my lord, capital to a complete anarchy.
I don't see
That's, my lord, my argument. And
it should not be an ambush procedure, Wallace. And your lordship.
So I'm saying something factual. I'm not arguing. To request. On Prem Kumar Jain, I may be permitted to file a 2-page note.
Sure.
But how it's not a good law, and your lordship.
You have the note right now?
No, I'll file it by tomorrow.
No problem.
Second, Lord, I have already filed an application seeking reference. I have already argued the points. So for that also I'll file.
No, but we didn't hear any argument on a reference of that.
At the end of the constitution bench, your lordship.
That was never argued. To a larger degree. This was never argued. We are now in rejoinder.
No, I'm sorry. I'll point out.
In fact, you were thinking.
Lord, the reference is needed. Lord, I have already argued the difference.
Solicitor, now it can't be now after Dr. Singhvi is in a rejoinder.
No, allow me, 2 minutes.
The reference has to be argued at the outset. We are now where Dr. Singhvi is virtually, you would have finished yesterday.
Lord, your lordships would recall.
We were also flagging in energy at the end of the day, and we thought we must give a fresh.
No, certainly. Your lordships would recall. When I filed the application and Dr. Singhvi objected, my lord said that he can always argue during his submissions. My lord, the Chief Justice were pleased to say. Lord, the reference essentially is on the ground that the contours of federalism between union and union territory requires a relook other than, my lord. So, my lord, I'm not, my lord, repeating anything. It is covered in my argument. I'll just put a 2-page note.
That is not.
No, your lordships in fact said that let it not be separately argued. It would be covered in his argument.
I mean, we would have looked at the matter very differently. I mean, there was the issue of reference was never been argued. I mean, we are now, your argument, your side is convinced.
I understood your lordship saying that instead of filing an application.
We'll consider. Dr. Singhvi?
Yes. No, his lordship should remember these 2 things. I mean, I wouldn't want to eat.
Only, my lord, before it. But I would honestly urge your lord, my lord, the Chief Justice. When I mentioned that allow me to circulate, my lord said that you can always cover it in your arguments.
But it was not covered in the argument. That's the point.
All points are covered without using the word reference.
With great respect, Wallace, this matter came before the division bench which referred it to your lordships about, Wallace, 10 times. I think Justice Kohli was part of that bench. 10 times over 1 year or 6 months. It was in fact listed for hearing, etc. Went to 3 judges. Justice Suryakant was there. Not at any time was a reference mentioned. No application was filed. Matter is listed by our lords for 10th. Just before that, a few weeks before that, it is raised. It is not told to your lordship that the prayer is identical to a review filed. This your lordship should know. 90006 of 22 by my learned friend. 4.5 years, 3.5 years after the 2018 Constitution bench. A review of that. This is nothing but the same thing. He files it, Wallace, on May of 21, 3.5 years later. He, Wallace, is saying that that judgment should be reviewed. Why? Because it is contrary to NDMC. That's the short point. Identical prayer in a review filed 3.5 years after the Constitution bench is repeated a few weeks before this bench is to convene. With great respect, for the lordship in the Constitution bench doesn't allow these things. What is the review? What is the reference for us? Reference is simply one sentence actually boils down to. There is a NDMC.
There are
9 judges.
Points which I have
sorry.
But I don't.
And it should be referred. Your lordship has dealt with NDMC, good, bad or indifferent, 10 times in the Constitution bench. What your lordship will do with it is your lordship prerogative there. You already dealt with NDMC. For that reason, it should be referred to now 9 judges or maybe 11. Well, with respect, this will be hugely dilatory. Your lordship has spent all the time. Today, Malas, we have gone into the constitution bench, we've gone into everything.
Lord, it can be anything but dilatory, my lord. We are
Yes, yes.
dealing with the capital of the nation, my lord, and therefore,
Capital
whether it is done today or tomorrow, my lord, that hardly makes any difference. My learned friend may be in a tremendous hurry to do certain things, my lord, but we are more on the future course of action, my lord. We may not be remembered in history for having handed over, my lord, capital to a complete anarchy.
I don't see
That's, my lord, my argument, and I have made those submissions. I'll just, Lord, put it 2-page note.
in
They
his
may be
entire 90
treated as
page and 54 pages, total of 140-50 pages, no reasons given for reference. Not asked. In his entire submission. Well, this is with respect. We can't repeat this capital, well, it's like a mantra every time. Of course, it's the capital. And it's the capital with the legislature, with representative democracy. Their argument is in the merit, nothing to do with the reference to 7 judges. Today, your lordships, having dealt with the entire 2018, so many paras, are suddenly at the end of my rejoinder, well, asked for reference. That would be very unprecedented for a constitution.
But I repeated that. I have covered the issues in my submissions. If your lordship permits, I'll place a 2-page.
May I start?
Yeah.
But can I place a 2-page note on that? Well, that's all.
I am objecting. This will go on and on endlessly. It will be made a ground subsequently for a 9-judge bench reference. With greatest respect.
No difficulty that you can certainly give your note because that's a question of law about.
I leave it at that. My lord. It's ultimately my lord's entire prerogative. Your lordships may only record that I reiterated, your lordships have not considered. That's all. It should not be, my lord, argued that it was argued and rejected. That's all.
It should not be an ambush procedure, Manas. And your lordship.
So I'm saying something factual.
This issue can
Can I?
Yes, my lord. It's a reasonable request that your lordship may record.
Yes.
Say that we are not going in.
No, Manas.